Lawyers of Reddit. What is it like to defend a client who is actually guilty? So, I'm a public defender, and I'd say most of my clients are guilty of what they were arrested for. My job isn't necessarily to get someone acquitted if they are actually guilty, it's to provide their constitutionally guaranteed right to counsel, protect their other rights, and act as a check against the prosecutors and police. I'm supposed to work for the best possible outcome for my client, and 95% of the time this means getting them the best deal I can and making sure the prosecutor is doing their job. But how does it feel to represent a guilty client? Well, I have moral obligations to drug laws and serious issues with the way they and many other laws are disproportionately enforced against people of color. When my clients are there for drugs or loitering and trespassing because they were black and at a park after dark, I rage internally at the bullcrap. It is an infrequent occurrence that a true sociopath that simply loves committing crimes comes across my desk. Most of my clients are there ultimately because they are poor and black or brown. That's why I got into this business in the first place. So generally, I feel A-okay representing a guilty client. Well, everybody, who would have thought that the very first answer we got was probably the best one? I have huge respect for this person as to why they became a lawyer. Massive respect. Love this reply from this person. But anyway, next story. Hi there, lawyer here. It's my freaking honor to do so. I'm not defending the person, I'm defending the Constitution. When I get in the courtroom, I see it as a clash between hundreds of years of political history and a microcosmic instance. You want my client to explain himself? Too bad. James Madison said no. You think he did it but aren't sure? Our founding fathers specifically wanted you to find him not guilty. I'm no magician. I'm a guy standing between the state putting a citizen in jail. And if the state would do its job, investigate its witnesses, and put on a somewhat competent case, they'll probably win. But you would not believe how often that does not happen. Every bit of government incompetence that you see in stark relief when you go to the DMV or the post office also shows up in police departments and prosecutor offices. That, plus there is often a hierarchy, so low-level prosecutors don't have the discretion to dismiss cases they should. As a prosecutor, I had a real joy prosecuting the bad guys, but thank God there are not nearly as many real crooks in the world as there are dumb kids who smoke pot and shoplift. And when you switch to the defense side, you see so much incompetence at a prosecutor's office that most never want to go back. TLDR, it's an effing privilege. Next story. As a defense attorney in the United States, it feels great. Why? Often you are not really certain. Many cases are built on slim circumstantial evidence. I always give my clients the benefit of a doubt when they say, as most do, that they are innocent. I have had countless cases where it becomes obvious later in the case that my seemingly guilty client was, in fact, innocent all along. So I diligently investigate every claim my client makes, no matter how far-fetched it may seem from a cynical perspective. Our justice system usually works, but it takes dedicated defense lawyers to keep zealous prosecutors from convincing the innocent. Unless you're representing somebody who is a sociopath or has a violent streak, most people become criminal defendants because they are down on their luck and are beaten by life and have become really desperate. I have no problem feeling compassion for somebody who has been less fortunate than me, and if that's not the story, then they're usually just dumbasses who screwed up. Giving them a break seems fair to me, except for the serial offenders who just never learn. I never feel bad for them. Although I agree that there is a problem with repeat offenders and criminals not getting caught. Once somebody has been caught, contrary to popular belief, the law frequently comes down on them like a ton of bricks, even for relatively harmless offenses. For the truly and obviously guilty, I think of my job as making sure that they are not punished any more severely than they deserve. I don't believe that it's fair to ruin somebody's life, and often the lives of their children and others close to them, because of a victimless crime or a minor property crime. Plus, doing so usually makes them even more of a burden on society. A huge percentage of cases are drug offenses. As a matter of principle, I have never believed that people should be punished for substance abuse, especially when the main difference between the poor and others is whether they can afford to get their buzz prescribed. I also believe that our drug laws are a huge waste of resources, and that the punishments are insanely disproportionate to the punishments for crimes that are far more heinous. So the bottom line is, the war on drugs is bullcrap, and it's incredibly destructive bullcrap. On most of my drug cases, I feel like I'm doing God's work. Then I'm not a cop basher, I support the police overall, and I'm grateful for everything they do, but cops lie a lot. Even when I know my client is guilty, it still pisses me off to see a cop blatantly lie about something I know to be untrue. A big part of my job is making sure that ethical lines aren't crossed by the good guys. And due to my personal values, I don't represent people on violent crimes or sex offenses. I am strongly judgmental, to the point of being vindictive towards people who deliberately cause serious injury to another person. So I just can't do that, because my heart's not in it. Also, the evidence in those cases is usually stronger than in other types of cases, so the odds are even more stacked against winning the case, and I hate to lose. Continuing, I've had very few clients that I considered to be bad people, so at the end of the day, I'm helping somebody. I find that incredibly rewarding. I also do my best to give advice and to counsel them towards not repeating the mistakes that got them in trouble. Although not always successful, I think I am actually pretty good at that, so I feel like I'm doing good for society, as well as my client. Big picture, I serve as a cornerstone of our county's values. Without defense attorneys, our rights wouldn't mean crap. I'm not only make sure that the laws are enforced properly, I actually enforce the most important law we have, the Constitution. I make no apologies for that, ever. Okay, so I lied a minute ago. All of these responses so far have been awesome. I know there's like the typical like lawyers are blood-sucking leeches cliche, but I feel like that's like more corporate lawyer stuff. But anyway, my heart is being warmed so far. Anyway, next story. So, defense lawyers play a crucial part in ensuring justice is done. Let's say an appalling crime is committed and an innocent person is arrested and seen as the main suspect. There would be a whirlwind, and many people react emotionally and think along the lines of, "This scumbag doesn't deserve a good lawyer. Give him some loser and let the judge and jury crucify him." But then the conviction is worth nothing. Only when a criminal has had every chance and his case has been scrutinized from every angle by a good defense can society be confident in the conviction and that the punishment is just. Next story. It doesn't really work that way outside of TV and movies. Just because a prosecutor thinks your guy did something doesn't make it so. You can suspect something, but a suspicion doesn't make you actually guilty. How do you know he's guilty? You're the lawyer, not the jury. It's the jury's job to find the defendant guilty or not guilty. It's your job to make sure that process of determining guilt was properly done. If the guy is truly guilty of sin, then the government should have no problem proving it. You're there to make sure they follow the rules when proving their case. So let's take a few popular examples. He confessed. Okay, let's find out about that. He confessed when he was interrogated for 18 hours without food, water, bathroom breaks, or sleep, or he was threatened with a gun to his head, or knocked around by a cop. Or maybe he was big-talking to a cellmate in order to not get picked on while he was in holding. Or it was a jailhouse informant who got a lighter sentence if he said your guy confessed. Of course, there's no audio. Or there is a 2-second audio clip where he said, "I did it," and they didn't provide the 2-hour conversation leading up to that, so you have no context. Confessions aren't as great as everyone says. If anyone tells you that I would never confess to something I didn't do, think about how that would change if they were being threatened and tortured. They'd probably crack in an hour. Next, everybody knows he did it. This is one of the most popular and the scariest. Rumors can't convict people. Rumors aren't evidence. Just because a guy is a jerk doesn't mean he committed a crime. Just because he committed a crime in the past doesn't mean he committed this crime. Just because he's of a particular religion, skin color, part of town, etc., doesn't mean he's guilty. Assumptions aren't evidence. Then what about there is an eyewitness? Google eyewitness reliability, folks. Memories are fallible. Eyewitnesses get it wrong. It's pretty scary how off they can be, especially if stressed. And okay, now let's switch gears and assume your client did exactly what the government said he did. And that's a stretch. The government will usually overcharge. You still have a few options. You can go through the process and make sure the government followed the rules along the way. You have to make sure the government actually has admissible evidence to back it up, and that the evidence is reliable and was lawfully collected. You cannot take government officials, prosecutors, police, etc., at their word. They can get things wrong or be overzealous in trying to solve a case, and someone can outright lie to get someone they know is guilty. For example, take a financial crime. How do you know that the document the government entered into evidence actually says what they say it says? Can you read it? Where did they get it? Do the numbers add up? And let's suppose the government did follow the rules and the evidence is solid. Even if your guy did it, was he set up? Did he understand his role in the situation? Did an overzealous police force trick or coerce him into doing it? Did the defendant try to get out of it before the sting? Did the government force him back into the sting? Next, okay, the government did everything correctly. Your guy did it. Your other option is that you can plea out your client. You have to make sure that the punishment is fair and reasonable. Do you trust the government to met out punishments all by itself? That's a lot of power to give to the government. You can try to argue that a lesser punishment is just, be a benefit to society, etc. Was there a mitigating circumstance? Do you trust the government, who just spent a ton of money convicting you, to be fair when sentencing you? That's a lot of trust to put into a public official. So yes, if the guy did it, you still have to do your job. If you don't, you'll wind up in a situation where you're jailed because everyone knows you did something. The government didn't have to prove it, you're just convicted. No one was there to fight for you. Next story. Not me, but my dad is a veteran criminal defense attorney. Anyway, he puts it this way: the justice system in itself puts an obligation for you to defend your client to the best of his or her ability to do so. And likewise, the prosecution has an obligation to try his or her best to prove guilt beyond a reasonable doubt. Then, on a personal note, he says the pay makes it much easier, but hey, they don't call attorneys blood-sucking parasites for nothing. P.S. I'm studying to be a lawyer too, and my mom is also a practicing attorney. Next story. I asked my uncle this. He's been a criminal defense attorney for 20 years or so, and he said to me, "You never really defend a client that's guilty, because guilty is a status determined by the law. I don't determine if they're guilty because I'm not the law, and neither does the law think that they're guilty either up until they're convicted. The moment they actually become guilty, you aren't really defending them anymore, but negotiating for their interests." Next story. So I'm not a lawyer, but I know plenty of lawyers and have actually asked this question before. Even if they are guilty, lawyers are just providing a service. Everyone deserves a fair trial, and lawyers are just doing their job. That's the mindset I've heard the most. You just have to do your best and believe that the client is innocent until proven otherwise. And even if you know they are guilty, how you feel about your clients should not affect your performance. There are also a lot of people that think lawyers that defend criminals are immoral. Most of them are not. They are just doing a job that is necessary in society. Me, I'm an escort, and I guess it is kind of similar when my clients are married men, which most of them are. I used to feel bad, but really I'm just providing a service. I'm not the one that is breaking my marriage vows, and if I didn't provide this service, then there would be someone else. Next story. My job isn't to walk guilty clients, but rather make sure the police and prosecutors have done their jobs properly. And if my client pleads/is convicted of any criminal conduct, it's for conduct he or she actually did. Also, more often than not, my role is one of mitigation, in that I know I cannot beat the case against my client outright, but I want to get my client the best possible offer. Then, police often bend the rules by conducting illegal searches, fabricating probable cause, etc., and prosecutors often do the same by not turning over exculpatory evidence. So it is my job to make sure every player in the system does their job by the book. Then judges in most jurisdictions are almost always former prosecutors, and they will do things that shock the conscience to help the prosecution. Often I have to appeal verdicts or file rights to remedy judicial action that is clearly biased and violates the constitutional rights of my client. But it is not my job to judge my clients. Rather, I liken my job to that of a triage surgeon who has to, objectively, look at the facts of the case and see where I can stop the hemorrhaging, so to speak. At the end of the day, everyone deserves a defense. If I were to start picking and choosing what cases I will defend, I'm not living up to my obligation to uphold the Constitution and the rights and protections it affords. Those who are accused of the most abhorrent conduct are the people who need to be defended most to ensure that both their and society's constitutional rights are upheld and protected from being slowly eroded by overreaching government action. It's very easy to not care about people who have been accused of repugnant crimes, but if we stop defending them, who will be forgotten next? Personally, I feel that the government is a bully, and criminal defense attorneys provide a crucial check on government authority in action. I like to think that we are the front lines, fighting in the trenches of an ongoing war against our constitutional rights. Next story. I used to work closely with a criminal defense lawyer. They weren't thinking in terms of innocent or guilty, but how can I get the best possible outcome for my client? Just because a person was in possession of a small amount of a drug or they were in a fight doesn't necessarily mean that they need a 3 years prison sentence. Judges can throw the book at someone if they aren't challenged, but at times, the lawyer can negotiate for time served or probation. Next story. Even in a case where the facts are clear, there's a lot of room to debate whether the label the prosecutor put on those facts is correct. Say that there's no doubt that A shot B dead. Depending on the context, it could be murder, 1, or it could be not a crime at all, or murder, 2. manslaughter, or something in between. If I can get the client convicted of, say, manslaughter instead of murder 1, he may do 3 years in prison instead of life without parole. At that point, I've done him a hell of a lot of good. A victory in the defense business can be lots of things other than a straight-up not guilty. Next story. I'll never forget this one client I had. Real piece of crap. But hey, it's my job to make sure he gets the fair treatment the justice system requires, right? So this guy was up for a long string of charges. I can't go into exact detail because he's still in appeals, but let's just say that the more serious charges rhyme with schmerst schmergree schmattery and schmasalt with a schmedley schmeppen and shattempted schmurder. Like I said, real piece of work. But being an attorney for guys like this is tough because you don't necessarily want to just throw your client to the dogs, but you also have an innate sense of morality. Luckily, I was a mid-level defense attorney, so I was able to strike a sort of balance, at least as was justifiable to me when it came looking to myself in the mirror and sleeping soundly at night. This particular client never actually admitted guilt, but anyone with common sense knew that he was all but standing trial before a jury of 12 eyewitnesses. Still though, the justice system and due process demand they be proven guilty beyond a reasonable doubt, and it was my job to scrounge up what reasonable doubt I could find for my mid-level defense attorney salary. I was not, nor am currently even a junior partner in my firm, so I had little reason to go above and beyond for any of my clients, let alone a piece of crap like this guy. But I wasn't exactly about to toss an alley-oop to the prosecutors either. So the first day of trial comes, and at this point we've been through multiple plea bargains that our client has refused. This guy was adamant that he was not guilty, and I wasn't exactly in the position to tip my hand and let him know that he was pretty effed. And when you're just another lawyer cog in the firm's wheel, you know what that's like. I tried a number of tactics and angles to get the guy to take a plea bargain, but he always refused. We actually had a fairly sweet deal at one point, but this guy was just that much of an idiot that he would rather go the entire distance with his not guilty plea and lose and spend 20 plus years in jail than bargain with the ADA. I don't think I'll even understand his rationale ever. So of course, the ADA brings out her A material during the opening statement, but she went far above and beyond what I ever expected her to do in the opening salvo. And this was after 7 years of trial experience, including my public defender tenure. I had never seen this kind of reaming even in TV shows. Judge Judy would have been in awe at this effing speech. Once she finished, I asked if we could recess briefly. I don't know if the judge was as blown away as I was or what, or maybe he just knew what I was trying to do, but he allowed it. Then I took my client into a side room and begged him to take a plea deal. Apparently, this ADA's opening argument had gotten to him as well, because he was very willing to accept, which was shocking considering his vehemence leading up to the trial and his attitude through the multiple plea bargains offered before. So, the ADA, myself, and the judge meet in the judges' chambers to speak about the possibility of a renewed plea bargain. Obviously, the ADA had the upper hand since it had gotten to this point, and she had just given a speech that the best writers in Hollywood would love to hear, but anything was better than the 3-week trial and 20-plus-year sentence my client was facing, for everyone involved, really. So, the ADA was sitting there looking rather smug, and I felt the judge also understood the upper hand that she had, but she still left it up to me to start the negotiation. She asked me what my client wanted and what I wanted. So I said, about tree fitty, and it was about that time that she noticed that I was about 8 stories tall and was a crustacean from the Protozoic era. And she said, "Damn it, monster, get out of my damn courtroom!" And they ended up taking the plea anyway, and my client got 8 years plus 10 probation. The TLDR is, you should almost always take the plea bargain. Next story. Guilty clients never make you nervous, but innocent clients keep you up at night, and endlessly so. When one of my clients is guilty, or at least appears to me to be guilty, it doesn't affect my feelings of the case at all. You have to take each case as it comes and decide the best course of action for your client as the case progresses. It's not an outrageous statement to acknowledge that statistically most people charged with criminal offenses are technically guilty of some offense. Something led to the cops being called, and the state is filing charges based on the officer's word. Many times, the state is wrong. Many times, they overcharge the crime for leverage later. Many times, the cops are wrong. Many times, it's just a misunderstanding. All of this happens frequently, and many times the client is totally innocent. But this is not the majority of cases. It is arguable whether most, or merely many, charges should be brought at all. Looking at you, probation, but that's a different conversation. We're there to protect our clients' rights and to achieve the best possible outcome, even if all of the potential outcomes are pretty awful. But onto your question though, I presumed you're worried about the guilty person going free scenario. In a perfect world, you wouldn't need to worry about it because the system would be flawless. If someone wasn't convicted, it would mean the state didn't have enough evidence, and since it is better for a guilty man to go free than an innocent man to go to jail, then the outcome was a victory for the rights of the individual. We all win. Since our current system has become dramatically weighted against the individual defendants, if a guilty person avoids conviction, the reaction is even more dramatic. You treat it as a miracle. For every one client that does avoid conviction, there are scores who do not. The last thing we have in the US is a guilty person going free problem. And don't let talking heads or tough on crime politicians try to tell you otherwise without evidence. Sometimes what a client did bothers you, but you develop a thick skin pretty quickly. After enough cases, you're so used to seeing your clients as more than the worst thing they ever did that you see them as a victim of one thing or another. Aside from the occasional a-hole, it's not like a-holes don't get arrested. Poverty, class pressures, violent environments, addiction, you name it. They're just like us. And it's not like we're anything special. They get groceries, they have a family of some sort or another, they watch movies. The only difference is that some crap went bad for them, and now they're cleaning up the pieces. It happens. What's infuriating is when the state gathers evidence in violation of your client's Fourth, Fifth, or Sixth Amendment rights. Guilty or innocent, it drives every defense attorney, or at least most, up the wall. Those principles protect all of us, and to see them tossed aside so casually because, well, he's guilty anyway, as many in the system view it, is just abhorrent. When those issues pop up, it doesn't matter what your client did. You want to fight it aggressively, and I take it very personally. The innocent clients, though, sometimes you just want to cry at how broken everything is. Next story. Just fine. My job isn't to make sure that innocent people aren't convicted, it's to make sure the state follows the rule of law. Now, I love nothing more than helping an innocent person beat a charge, but innocence or guilt is not really the purpose. If the state can't follow the rules, why should my client or anyone else? The state has all the power and money and many times set up the rules in the first place. Why shouldn't they have the burden of following those rules? This only applies to criminal law. Civil law is different, and many times if you are on the defense, you are trying to limit the fallout to your client to the best of your legal abilities. But there's a reason I focus on plaintiff's side work and criminal defense over civil defense or prosecution. Next story. I have always said that I honestly believe it would be emotionally harder to be a prosecutor than a defense attorney. My job is simple. I always represent my clients to the best of my ability. It's not my job to win a case. It's the prosecutor's job to prove my client guilty beyond a reasonable doubt. If a client who is guilty of mine walks, it's because the prosecutor could not or did not do their job of proving him or her guilty beyond a reasonable doubt. Plus, I love that my job matters. My representation of a person could determine if they go home and have dinner with their family or spend the rest of their life behind bars. The prosecutor, on the other hand, has to decide what crimes to charge a person with, what offers to make to resolve a case, and what cases to proceed to trial with. If an innocent person goes to prison, that's because a prosecutor made a mistake in pursuing those charges. I think that would be a lot harder to sleep with. Next story. I interviewed for a job as a public defender. One of the questions was, how would you react if you got a guy off for essaying a 3-year-old girl, and afterwards, he admitted to you that he did it? Well, the answer was, you couldn't do anything because of attorney-client privilege, unless you knew of another crime that was imminent, which from the fact patter, it wasn't. In any case, she was like, you're going to see stuff like that all the time. How will you sleep? And I think most do it either by not caring or by looking at it as necessary for the system to function as a whole. Yes, rigorous defense of criminals will ensure some guilty people go free, but it will also ensure some truly innocent people do as well. Next story. Really, as a lawyer, you believe in the justice system, and you want it to work properly for the benefit of society. As such, in criminal proceedings, you know the importance of innocent before proven guilty. You know that you would prefer a guilty man go free than an innocent man be wrongfully convicted. That said, at least in my jurisdiction, you have a buffer where if someone admits to you they did it, you can't represent them in telling the court they did not do the actions they are accused of. You can only try to put the prosecution to proof, essentially to pick holes in the case they establish. You can't lie to the court. The issue comes about when you know they are guilty but they won't admit it to you. Usually, though, you know based on the brief of evidence, and you know that them pleading not guilty will essentially mean a harsher sentence. No sentence discount for an early guilty plea. That being said, lawyers are human, and we have less rational components of psyche. I am not the right person for the job if my emotional side kicks in and I feel personal anger towards my client. For me, this has happened where a predator wants to plead not guilty when clearly, on the evidence, is guilty, thereby dragging the victim through at least one terrible trial and inflicting more harm on an already broken person. Many lawyers, though, can see the bigger picture of the importance of justice. I do not have the capacity for that in those particular situations, and so someone else is ethically better for the job. In terms of the personal part of being a lawyer, defending high-profile clients, as in local news coverage, not celebrities, can cause friction with family and friends. I've worked on some cases, not been the lawyer running the case, and had my in-laws so angry that I would defend a baby killer. Client confidentiality and the need to keep our defense top secret makes it very hard to explain yourself in those situations. You learn to deal with that, though, and avoid talking about work. Next story. So I'm a retired prosecutor in Ohio. The shoe on the other foot is the horror, the absolute nightmare at the thought that I may have convicted an innocent person. I put several murderers on death row, but none was ever executed. Appellate court would find some way to avoid the death penalty. Several times during a trial, I would receive evidence that would make me doubt the defendant's guilt. Case dismissed, just like in My Cousin Vinny. Alright guys, I'm going to tell you something I have never publicly admitted. Not that I'm ashamed of it, but this person just mentioned the movie My Cousin Vinny, and Marissa Tomei's character in that movie I think about all the time and has awoken something within me. I don't know what it is, but I love that accent, and I may need to move to New Jersey or Boston or something, I don't know, and go find it. So thanks a lot, Marissa Tomei. You have ruined and improved my life. Anyway, yeah, next story. I had a criminal law professor who, in response to this question, mirrored the top comment in this thread, but also said the only time he ever felt bad about his job is when he was defending a party he believed to be innocent, and they got convicted. In that scenario, he didn't just fail them, the entire system did. In the scenario that a guilty person walks free, well, then that's the crown failing. It was an interesting perspective, and one I carry with me. Next story. Guilty is decided in court. Usually, your defense attorney really doesn't want to know too much. Either they want just enough information to create doubt, or they want to find a feasible excuse to waive you from harsh punishment. It's really more about providing a service based on a constitutional right than anything else. I don't know any attorneys that revel in setting the murderers and SAers of the world free just because they can. Next story. My criminal law professor, who is also my advisor, explained it like this. It isn't your job to ask if the person is guilty or not. The jury are the fact finders in the courtroom. When you meet with your client, you ask specific, non-incriminating questions to determine what defenses are available to use. If your client begs to incriminate himself, you stop him immediately. If he admits to you a crime privately, you will then be a witness to perjury during the trial if he testifies otherwise. But he was a renowned defense attorney in New Jersey who was terminated from the university last year for reasons unknown to us. I suspect it was his unorthodox teaching methods or his short temper. Next story. Bird lawyer here. Most of the time it's okay, but the job has been known to ruffle my feathers. Sometimes clients are guilty. This I can deal with. But when they fly off the handle and get aggressive, it gets to me because there's a pecking order. Two can play at this game, and I'll say maybe I don't necessarily represent them as well as I would have done. To be honest, bird law is distressing, and most of my clients end up behind bars. Next story. This is a great question, but I think most of the lawyers answering are kind of deflecting the issue. Whether or not something is right or wrong, drug laws, whether or not a defendant gets his fair day in court the way everyone deserves, that's what you're there for, how does it feel to defend a client who is guilty? Instead, most of the replies are, it feels great to defend the Constitution, or I don't know he's guilty. Then, two of the prerequisites of the question aren't being met. Some of the questions are detailed, thought-provoking, and very insightful, but they also don't answer the question that was asked. What if your client was accused of murder? Take the incident of David Westerfeld. After the trial, it was reported that his two attorneys, Stephen Feldman and Robert Boyce, told David to plead not guilty despite the fact that he was willing to lead the police to the body of the girl he essayed and murdered. However, search parties found the body before the plea bargain was made. The real question is, how do those attorneys feel to have to defend someone who is about to lead them to an essayed and murdered little girl? Next story. Not a criminal lawyer, but one of the oldest principles of lawyering and one that remains extant in many jurisdictions is the cab rank principle. It remains the case that for barristers, you cannot turn down a case in your area of expertise if you're free to work and the fee will be reasonable. Criminals normally get legal aid, so for criminal lawyers, money's being paid by the state. And legal representation isn't about winning or losing, it's about doing the best you can for your client. Whether it's a criminal case or a commercial case, the duty of the lawyer is always to the administration of justice and to their client. But yeah, everybody thinks some of their clients are assholes. Well, folks, this has been a very fun and insightful video. We also got Charlie from Always Sunny in Philadelphia to talk about his experience of being a bird lawyer. And also, the comments here were so eloquently written at times, some of them, yes, kind of skirting around the question, but I still feel like I learned something. Sometimes when narrating these videos, there's people who don't know how to write English very well, even when it's their first language, so everyone here displayed immaculate English skills, and that allowed me to narrate this video better, and I really enjoyed doing this one all around. But anyway, guys, thank you all so much for watching, commenting, have a really good day, and bye!